First case to come before us this morning is Daniel K. Wright III versus Ohio Department of Job and Family Services. Each side will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, if you could let me know when you get started, I'm keeping track of the clock. We have read the briefs and we are ready to proceed when you are.
Thank you. You can hear me?
Yes.
Okay, thank you. Good morning, and may it please the court. Becky Thomas on behalf of the Ohio Department of Job and Family Services. I'd like to reserve 5 minutes, please.
Certainly.
For rebuttal. As the court knows from the briefs, we are here to appeal only the fee award. We are not here to appeal the merits decision. We asked the court to vacate that fee award because it was issued without authority. We have in our legal system the American rule, which says that you don't get your attorney fees paid for by the other side unless a statute authorizes it, or there's a finding that you've engaged in, or the other side engaged in bad faith conduct that rises to the level that justifies an award of attorney fees. In this case, Mr. Wright asked for fees under one authority, and that was a statute, Revised Code 2335.39. And the court issued its award of fees only under that statute and under no other authority. It made it very explicit in its decision that it was talking only about 2335.39. That statute precludes attorney fees under that statute. Its provisions do not apply to an entire category of cases, of which this case is one, and that is appeals to common pleas court under Revised Code 5101.35. That's in part F3C of the statute. You may remember from the lower court's decision that court relied heavily on a first district decision from 2003. It quoted that decision at length. That's the Hagigi case. I don't know if I'm pronouncing that correctly. It's my best shot. Quoted extensively and discussed that case extensively. And the problem with that is that case was decided before F3C was in the statute. There's another provision that was in the statute then that's still there now that we think also precludes fees in this category of cases, but it's not nearly as clear. 4 months after the Hagigi decision came out, after not having touched the statute for about 12 years, the General Assembly amended the statute and added the phrase or the terms that amount to no fees under this statute are allowed by this statute if it's an appeal taken under 119.12 pursuant to 5101.35 to appeal from an administrative appeal decision, which is the only kind of thing you can appeal under 5101.35. So once you have 5101.35 in the mix as the appeal mechanism, this entire class of cases is covered by that exclusion. The lower court acknowledged and mentioned F3C, but it really analyzed F3A. And it concluded that this wasn't a hearing. At the agency level, the hearing was not a hearing to determine entitlement to benefits. And we disagree with that, but we don't need to go there because F3C is a completely airtight seal around this category of cases. The General Assembly said this statute allows fees in some cases. One of the categories of cases where fees are not authorized by this statute is appeals under 5101.35. I don't think there's any way around that. And there hasn't been any way around it articulated by the lower court or any valid way, let's say, by Mr. Wright either. That provision, and Mr. Wright is still, in his brief, he's still defending reliance on the Hagigi decision, which even if you concede that, even if we were to agree that Hagigi was correct, it wouldn't matter because F3C makes fees unavailable under the statute in this case. Mr. Wright argues for the first time on appeal that instead of looking to the statute then, if the court doesn't think the statute authorized fees here, the court should affirm on a different basis, which is bad faith attorney fee award. There are several problems with that theory. First of all, it's waived, was never raised below. Mr. Wright never asked for fees based on bad faith conduct. The court never analyzed the bad faith standard. It never made findings under the bad faith standard, and it very clearly issued fees under the statute only. And in this case, because a fee award for bad faith would have required different findings of fact, perhaps an evidentiary hearing, it really would be changing the judgment to affirm on that basis. It's not just the routine case where the court is affirming on an alternate basis, which, by the way, is reserved properly only for cases where grounds were raised but not adopted by the lower court. Here, we don't even have that. But the court would be changing the judgment, and Mr. Wright did not file either a notice of appeal or a notice of cross appeal, and so this court doesn't have jurisdiction to do anything that would change the judgment below in Mr. Wright's favor. An important factor in all of this is that had ODGFS known that this was in the mix, that the lower court was considering a bad faith fee award or would have considered one, it would have defended itself against that. But it was given zero notice that that was an issue, even after we pointed out in the response to Mr. Wright's motion for fees, hey, you're not arguing bad faith here, you're just arguing under the statute. And so here's our defense under the statute. There was never any discussion, even after we raised that point, that bad faith was an alternative basis for fees. It just wasn't ever argued or raised. So it would be unfair to affirm on that basis when the department had no opportunity to defend itself, and certainly would have, and there probably should have been an evidentiary hearing before the court could make factual findings, because that standard involves so much intent-based factors, so many intent-based factors, the department surely should have had the opportunity to bring witnesses to testify about that. But that's all under the bridge now because it was waived. But I just want to point out how unfair it would be to affirm on that basis when we had no opportunity to defend and no notice that we had to. And finally, because the review that this court would apply to a bad faith fee award would be the abuse of discretion standard of review, it follows that the court below would have had to exercise discretion before this court could review that discretion to see if it was abused. And that's not what happened. The lower court looked only to the statute and did an analysis of that statute and concluded erroneously that it didn't exclude fees here, and then awarded fees under the criteria in that statute, which are different from the bad faith criteria. So this court, it's not like there's a de novo review where the court can say, well, we can look at it anew because we don't need anything from the lower court to decide what should have happened here. This would have been a discretionary call, and it didn't happen. So for those reasons, we're asking the court, and I'll stand on our briefs for the rest of the arguments unless the court has questions. For those reasons, we're asking the court to vacate the fee award, and I'll reserve the rest of my argument for the rebuttal. Thank you.
Thank you, counsel. You'll have 5 minutes for rebuttal.
Thank you.
Counsel for Mr. Wright.
May it please the court, Thomas W. Coffey, Coffey Law LLC, Cleveland, Ohio, for Daniel K. Wright III. The critical thing that has happened here is that a court of common pleas has made a decision that fees are required in this case, and the court was not shy about its findings. The court held in its opinion that it would be inequitable not to award fees in this case. Very significantly, the Court of Common Pleas here did not just reach that conclusion by looking away from the facts of the case. The Court of Common Pleas very carefully reviewed what happened in the underlying case itself, where the state of Ohio lost and lost badly and didn't even try to appeal the finding. And the Court of Common Pleas, in its consideration of the extensive briefing that went on at the fee level, because that was thoroughly opposed by the state at the time, made the findings that the conduct of the state of Ohio in this case was unsupported and oppressive. The Court of Common Pleas held that had the ODJFS had a broader focus from the outset, it's likely that this matter would have had a much shorter administrative life and never would have reached this court. When a Court of Common Pleas, looking at the facts this carefully, finds that the conduct of a litigant in the court was unsupported and oppressive, it is very difficult to sit here and listen to somebody come in and say that under a statute that invoked the court's power to look at this in the first place, what the court did was wrong. Guess what? Courts do not play word games in the state of Ohio with what has gone on in statutory construction or the rest of it. This
Counsel,
time,
let me interrupt you for a second, because you began by saying the court said it wouldn't be equitable. Does the court have the right just to ignore a statute?
the court certainly never has the right to ignore a statute. Nobody would argue that, and we don't argue that. But this very argument that's being made by the state has already been raised in a case that we cited in our brief, Thomas versus the city of Cincinnati, where the city of Cincinnati was found to have engaged in similarly inequitable conduct. And the argument was made that the statute was too narrow to support the fee award that was made by the court. The court went through the analysis very carefully and said, look, in Ohio, it has always been the law that a court of common pleas has the right to make findings based on the conduct of a litigant in its court and award fees under certain criteria. The criteria are, it has to involve bad faith, vexatious conduct, wanton conduct, obdurate conduct, or oppressive conduct. We actually have that in this case because the court was indeed not ignoring the statute. The court looked at this and said, this is unsupported and it's oppressive. And that statute that they were looking at when they did that was actually the state's adoption of the Federal Equal Access to Justice Act. That thing was put in to keep the state of Ohio, with all of the money that it has and all of the resources it has, from abusing people who are in a lesser position. Danny Wright in this case was a young man confined to a wheelchair. The wheelchair and Mr. Wright together weighed 600 pounds, and the state wanted to force him to roll up and down out of a modified bread truck on a ramp that had too much incline to it. It is really tough that the state comes in and takes a position like that and then tries to escape the court's finding based on a quirk of statutory law. It isn't the statute that does it here. It's the court's inherent power to find this, and the court did it. Now, there are cases that are very explicit in Ohio, and I've cited them in my brief, that say, look, once the court has made a finding that fees are appropriate, that finding can only be reduced or can only be eliminated under an abuse of discretion standard. We don't have anything close to abuse of discretion in this case. And the state of Ohio tries to cite the case of Soren versus Board of Education for the proposition that indeed it's only the statute that matters and nothing else. There is an incredibly critical distinction in the Soren versus Board of Education case. It says further, neither the Court of Common Pleas nor the Court of Appeals below expressly held that appellant's actions in seeking to terminate appellant's contract were of the character of being bad faith, vexatious, wanton, obdurate, or oppressive conduct. In this case, the Court of Common Pleas has expressly found that the conduct was unsupported and oppressive, and they also found that there was an obdurate refusal of the state of Ohio right from the beginning of that case to consider the evidence that was in front of it. You know, we have to think about what happened here. The Court of Common Pleas, acting as an appellate court here, had to look at all that evidence and go through a really extensive case. And I'll tell you, I'm getting to be an old guy, but I was up till 3 a.m. many times putting that together for them. This is what the state is not supposed to be able to do, to just ignore the evidence, keep putting it to people and keep requiring them to go through these procedures. The legal work in this case cost $27,000. In the end, the Court of Appeals awarded $32,000 to Mr. Wright. It's pretty obvious that if the money that it took to get that result is not included in the fee award, the economic consequence is pretty severe. The state should not be able to use its superior economic power like that to discourage people like Danny Wright from asserting their rights under state and federal law. And that's what happened here. There used to be a highway sign when people did work on the highway that said your tax dollars at work. This shouldn't be my tax dollars at work to keep the state in a position of superior power and keep the law from being able to be enforced because people don't have the economic resources to fight it. And that's what the Equal Access to Justice Act was all about. And that's why in my brief, I said the court's reliance on Hagigi was not misplaced here. And the Court of Common Pleas did a good job in this case. They were pretty careful to say, we find that reasoning to be applicable. Not the statutory language specifically, but the court found that the analogy to Hagigi and the Equal Access to Justice rule was appropriate. And the court did that after very careful analysis. The state has never explained how they think they can get past that abuse of discretion standard. But certainly there was no abuse of discretion by this court in making the factual findings that it made to support the fee award. My goodness, I was expecting to be peppered with questions.
Was there any discussion at the trial level regarding fees that were not statutory in nature?
Well, you know, the reference to the trial level is important here because in this case, there never really was a trial. There was a bunch of administrative procedure that resulted in an appeal to the Court of Common Pleas, and the appeal was conducted strictly on briefs and obviously through the court's responses and its holdings. One very detailed opinion, 27 pages long, that set forth everything that happened in the appellate level and why those things were wrong. And frankly, a finding that the state didn't produce any evidence. You know, it was very interesting. At the administrative level, the state was under the obligation to bring forth reliable, probative, substantial evidence that supported its findings of fact. The state couldn't bring forth anything. The Court of Common Pleas was a model of discretion and professionalism here. What they said was that the evidence was paltry, that the state adduced. That's a gift to me because when I retire in a few years, I'll always remember the word paltry and what an interesting choice of words that actually was. But they compared it to the very substantial, reliable, and probative evidence that we adduced on behalf of Mr. Wright in the case. We believe that that's really important because the state wasn't even close here. The state was never in the ballpark. They just tried to mash this thing through and think that Mr. Wright would collapse. And that's why the Access to Justice Act was appropriate. That's why the reasoning of Hagigi should be upheld under a liberal enforcement of the terms of the Equal Access to Justice Act. But much more importantly, when a litigant comes in and the court finds that what they did was oppressive, it was unsupportive, when they use words like unyielding resistance to consider the evidence, it's worse. And it's worse in this case because it's not just some private person who became overwhelmed with emotion about their case. This is the state of Ohio. By golly, the state of Ohio should not be coming in and trying to force things through with no evidence and engaging in obdurate, unyielding resistance to consider the evidence. For shame. That should not happen.
Counsel,
Yes, Your Honor.
I understand your argument, and your argument sounds like a really nice policy argument that you would make to the state legislature. The court said, I'm looking under the statute. So what do you do with that?
I'm sorry, I didn't hear the last part. The court
I
said,
apologize. I said the court said that she was looking under the statute. She says, I have to consider the criteria under the statute. So how do you get around that?
we
I
don't
mean-
have to get around that, Your Honor, because it turns out that the criteria that the statute sets out, where you're looking for oppressive behavior, unyielding behavior, obdurate behavior, happens to be the exact same standard that a court considers under the exception to the American rule, where they have the inherent power to award fees. If that weren't true, we would have the problem here that the court describes, that the lower court looked under a statute and that's where this originated from, but the standards are exactly the same. And that's what the court held in the Thomas case. I've cited that in the brief. That was a case where a fire chief was engaged in administrative proceedings in the city of Cincinnati. And it's significant because this case, as the state has pointed out, involved administrative proceedings. So did the Thomas case. The same arguments were made by the city of Cincinnati there and overruled by the Ohio Court of Appeals for the First District.
Counsel, let me interrupt you. Again, I apologize, but what about the fact that the state, everyone was arguing under statute, that's my understanding. So what about the state's right to have notice and be able to defend on the basis of bad faith, basically?
That would carry a lot of weight if the standards weren't the same. But the statute that authorized the fees here actually looks to the same standard that's the common law standard. They had their chance to argue under our adoption of the Equal Access of Justice Act, which they now claim is inapplicable. They had the chance to say, hey, our conduct wasn't oppressive. It wasn't unyielding. It wasn't an obdurate refusal to consider the evidence. But you know what? The court has already made those findings. Those findings are now binding unless this court finds an abuse of discretion. And further to your point, Your Honor, if that became a real issue in this court could remand it to the Court of Common Pleas and say, hey, conduct a hearing. Let them come in here. Let the state come in and explain why what they did wasn't oppressive. Let the state come in and explain why it wasn't obdurate. Let the state come in, but you have to realize and effectively argue with the findings that were made by the lower court based on facts. Those findings are already in the record. That's why we didn't say.
I'm sorry, I have one last question. I know you're running out of time, so that's the reason why I'm interrupting you. I apologize.
Certainly, Your Honor.
I guess I'm still wondering about your response to FC3, which says it's not applicable to administrative appeals.
Actually, what the court did was make it clear that they thought the reasoning of Hagigi was applicable in this case. The court actually made a distinction there in its holding. It said, we don't think that the conduct here was as oppressive as it was under Hagigi, but nevertheless, we're persuaded that the reasoning of Hagigi applies here. And the reasoning is just that if you go outside the scope of what you're allowed to do and you get into obdurate, oppressive conduct, then you're not entitled to say that the fees don't apply. So I think that that's a pretty critical distinction. And that's why I said the Court of Common Pleas was careful and reserved and did a good job with that opinion. I think it's very difficult for somebody to say, hey, we think this is an abuse of discretion and set that aside, especially where the factual standards are identical.
Thank you, counsel.
Thank you, Your Honor.
Counsel for the state, you have your 5 minutes of rebuttal time remaining.
Thank you. Hagigi was decided before the statute was amended. It says nothing about F3C. F3C takes over and says you cannot have fees under the statute for appeals under 510135. It doesn't matter what Hagigi said. None of that matters. The court below was wrong to rely on Hagigi. Mr. Wright was wrong and still is wrong to rely on Hagigi. That case is superseded by statute. No fees are authorized by the statute for 51-135 appeals, no matter what else might be said about the case. That is open and shut. We have to go to the other argument Mr. Wright has put forth, and that is that he thinks that the court can affirm on different grounds that would have required different factual findings. He says the standards are the same. They're not the same at all. The discussion in Hagigi and by the lower court about the reasons for the enactment of 2335.39 include the desire to prevent the state from engaging in oppressive conduct without compensating people for that. The standards in the statute are that the state can come forward if it wants to and try to defend its position, saying it was substantially justified when it initiated the matter, if it initiated the matter, which, as we briefed, didn't happen here. So the statute wouldn't apply anyway, because the state didn't initiate this matter. And I'm not going to go into that unless you have questions, because we briefed it, I think, pretty well. My colleague briefed that. But the standards in the bad faith conduct are all about intent for oppressive reasons in bad faith, with intent to mislead. We gave examples in the brief. Usually it's applied in cases involving tortious conduct, ignoring multiple court orders, delay tactics, engaging in needless litigation. We didn't bring any litigation below. That was all Mr. Wright. He asked for a hearing, and he has a right to do that. But he asked for a hearing. He asked for an appeal at the agency level. He asked for an appeal to court. We were brought into the proceedings. We didn't start the proceedings. He came and asked for a benefit. The state said no, and he challenged that. And ultimately, he was successful. That's fine. But the statute doesn't look at intent. It looks at the standard for substantially justified, by the way, which is the only place in the statute where it comes in what the state's position is whether a reasonable person knowledgeable in the law would agree that the state had a reasonable position when it initiated the matter. There's nothing in, it's an objective standard. The bad faith standard is subjective, and it's all about intent and abusing the judicial system. None of that is apparent from anything in the record. I challenge anyone to look at the record. The transcript of the hearing is in the record. The hearing officer let everybody ask the questions they wanted to ask. The hearing officer asked questions. The state hearing decision is explained at length. The policy is laid out. The analysis is laid out. State disagreed that the 3 invoices could be broken up. The state thought the cost cap was exceeded. That's not obdurate. That's not bad faith. That's a legal conclusion that the court disagreed with, and that's fine. Reasonable minds can differ. Nothing in the record shows bad faith. And when the court said the phrase unsupported and oppressive, that was echoing words that Hagigi had used in describing the reasons for the statute's enactment. And something being oppressive is the effect on a person. For oppressive reasons, which is in the bad faith standard, means that the person who is acting did it for oppressive reasons. That's not the same as conduct being oppressive to someone. That, again, is about intent. It's a subjective standard. So the standards are entirely different. I don't even see any overlap there. And also the idea of remanding this case at this point, the time to argue this, if it was so obvious that it should be argued, it should have been argued at the common pleas level, and it was not. In fact, it was specifically given up. We even mentioned it in our response. It still wasn't ever mentioned by Mr. Wright or by the court. So the court should not give Mr. Wright an unfair second bite, because we favor judicial economy in our legal system, and you're supposed to bring all of your arguments at the first opportunity to the lower court. And if you don't, you live with it afterwards. You live with your choices like all litigants have to do. And again, Mr. Wright seems to still be defending the fee award based on the statute and ask for liberal interpretation. Well, that only applies if the statute's ambiguous. There's nothing ambiguous about saying that this statute does not apply to appeals taken under 5101.35. There's nothing ambiguous about that. We briefed the more specific issues at length, and I think I'll leave most of that, but I just want to point out quickly that it's just not true, and the court can read the record and see that it's not true. It's not true that the state had no evidence. It's just not true. The lower court disagreed with how the evidence was weighed, but witnesses testified that they talked to the manufacturer and came away with certain ideas about what could be a separate item and what couldn't. And they applied the $32,000 against the $10,000 cap and said that's too much, and decided that the breakup wasn't appropriate for reasons that are not oppressive. They're not bad faith. They're not wanton. They're not reckless. But certainly there was evidence that the state brought up at the hearing. And most of this is legal questions anyway. You don't, if someone brings in a mountain of evidence, but the question is a legal one, it's not a fair criticism to say that the other party didn't bring its own mountain of evidence because it was a legal question. There wasn't a factual dispute here. There was an application, there were certain modifications to the ban being requested, and the state decided whether under the law that applied, those applied to those facts, if that entitled Mr. Wright to those benefits, and it decided that it did not. It wasn't so much an evidentiary dispute as a legal dispute at that point. The state wasn't disputing what was going on. Excuse me. Yes.
I'm sorry, I might have some background but thank you both. I have allowed both of you to go a little over time. Thank you both for your oral arguments today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Our next video